Hello and welcome back to Attorney Paz's Rants of a Criminal Defense Attorney. I haven't done a video in a few weeks. I was on vacation with my family, and then the last couple of weeks my husband's been away on training, so I have been barely making it. So this week I definitely want to talk about, some injustice that happens around in court, especially when you are charged with violation of probation. So one of my first rants was about a client who had been on probation, owed a little shy of 5 years of probation, and then gets arrested in connection with a drug investigation for which there really is very little information to suggest that he was actually involved in this drug scheme. But the problem is that it will still trigger the violation, and now you owe almost 5 years, and your choices are to either go forward with a violation of probation hearing and take the chance that you lose, and then you may pull all of what you owe, which is obviously almost 5 years. And a lot of this is dependent on the judge that you get for the violation of probation hearing. So on the underlying drug case, I had a lot of suppression issues. I thought I could win that case. I mean, if he was in charge with violation of probation, I probably could have taken that to trial, and there was a really good suppression issue, and then we could have won that case. But the problem is that suppression motions do not hold water in violation of probation hearings. So there is case law that says that when you're on probation, you essentially have no rights, and anybody could search anything that they want from you, and it's okay. They could essentially never have probable cause for anything to search anything, and they could search it. So that suppression issue wasn't going to work in the violation of probation hearing, so I couldn't suppress the issue. And then also the secondary issue was I didn't know what judge we were going to pull for that hearing. And so if it was one particular judge, I knew he was going to pull all of what he owed, regardless of how bad it was. If it was another judge, it may not have been so bad. I probably could have made some mitigation arguments that probably would have been okay. But in the end, the state attorney knew that he did not want to go forward with a violation of probation hearing, and so, threw out this crazy number, so he only owed almost 5 years, and the offer was 2 years and 9 months, and he had no choice but to accept it. And this is a man who doesn't think he did anything wrong, and there was a lot of evidence to suggest that he didn't in fact do anything wrong, and he had to take it because he has 2 young children, and he didn't want to go to jail for almost 5 years, and he wanted to mitigate the amount of time that he had to go in. So is that justice? No, it's not. It's a preponderance of the evidence at the argument for violation of probation. I can't present any evidence that the police violated his rights by searching his phone. I can't argue, I could argue that, he wasn't involved, but because of the lower burden of proof, I was probably going to lose. So this is a man who's going to jail, who likely didn't do anything wrong. He didn't have any connection to this drug case. That's my rant for the day. If you're on probation, you have lesser rights than the rest of us. You are under a microscope. You cannot be picked up for anything. It's really not advisable to go forward with violation of probation hearings. So if you have any questions about that, feel free to email me, Brittany@RowenaAttorneys.com. And as always, take care. Don't get arrested, especially if you're on probation, and see you soon.